Welcome back again, viewers and listeners. My name is Timothy Sweet. This is the podcast, What Just Happened? Surviving the Family Court. We are produced by Patricia Raskin of Raskin Resources Production in conjunction with Tony Jones of Rhode Island Free Radio. Video is provided to us this week by Guillermo Javier Garcia of Pixels Digital Productions. We thank you for joining us on any one of the many podcast mediums or on YouTube or wherever else you are finding us. We are settling into episode 6, which we're calling The Illusion of Control. And if you are tuning in the first time, this podcast is, we hope, and will become, a bridge between the beginning and the end of your family court matter. And a bridge that if you listen to each episode, we hope will help you in your perspective of the court and how to best traipse over the bridge and get to the other side of the toxic swamp that is and can be the family court with your dignity intact. We hope you found this podcast enlightening and revealing so far. And at the end, I think, starting on this episode, I'm going to really ask for listener and viewer feedback from you. We'd like to hear from you and address your questions, concerns, or advice vis-a-vis the family court moving forward so that we best know how we can serve and suit you. And of course, we'll make every attempt to address your specific issue or concern while protecting your confidences. You can send anonymously if you want, but if you do send us a question that you have on your mind or something that's keeping you up at night regarding your family law matter, and you do disclose who you are or what the nature of the case is, you can rest assured that we will, of course, redact and protect all of that. You might be surprised, listeners and viewers, that no matter how specific the question is that's worrying you, there are other people suffering from the same concern you are. You're certainly not the first to experience this difficulty, and by sending us your questions and by giving us an opportunity to help, assist, or guide you, we'll also be guiding all those who are going through a similar problem for you. I would much prefer that this podcast become more of a discourse between our listeners or our viewers than just me and my soliloquies on my own experiences in the family court moving forward now that we are underway on episode 6. In the last 2 episodes, we did a bit of a deep dive into the secrets, values, and lessons of the family court. And while incredibly important, and when we emphasize the secrets, and I'm proud and glad we talked about that, I also found the discussion a bit heavy and also more than a little abstract and theoretical in parts. And so I'd like to pivot in this episode, episode 6, discussing control and realizing that while episodes 4 and 5 were inescapable, nonetheless, I do want to get back on the right track as far as being tangible and pragmatic and helping you, each of you, on a day-to-day or court appearance to court appearance basis. So we're going to try as best as I'm able to turn away from theory this week, and I'd like to discuss some rather fascinating dynamics of the family court as I see it on the inside, specifically the idea of control of the family court and who holds it and how they wield it and how to use that control in order to bring your family court matter to a quick and satisfactory end. And like all the discussions, I'd like to be as candid as possible for me in the hopes, the grandiose hopes maybe, that this podcast can be a catalyst or even a real help for both the family court attorneys and the family court parties, and thus ultimately to the attorney-client relationship, which in family court, for several reasons, does tend to burn very brightly and very quickly. My starting point on control is that we attorneys don't have it. The attorneys have precious little power and control in the family court, despite the misconceptions. Your attorney, as soon as your case begins, is hemmed in on all sides, from the evidence, in the macro sense, from the needs and desires and the expectations of the client. On the other end, to the preferences and picadillos of the judge appointed to the case, what he or she does and does not like, does and does not tolerate, and more specifically in the micro sense, from the court date assigned to the rules of procedure to the rules of evidence, attorneys are shackled from the get-go by what has transpired in the case already. If you hire an attorney after a court date or two has passed by, and by the first impressions made by one or both parties before the judge, before the attorney is even retained. If further hemmed in by the age, maturity, and needs of the children involved, by the criminal history of one or more parents, by the financial resources of the parents, and on and on and on. And you may be thinking, well, if the attorneys have very little power, then who does? And how does this system work? Well, to be honest, no one does, which is why the family court can be so chaotic. The judge, of course, and the clerks are the real chess players. The attorneys in the family court are often left to do their very best dancing while stuck between several immense rocks. I'll give you some examples that I've experienced and that I know my brother and sister family law attorneys experience on a nearly day-to-day, case-to-case basis. There are often things that a party who is in action to a family court case wants his or her attorney to do or wants his or her attorney to address, and the attorney cannot. Just for one example, I may be asked to put forth a certain argument and know for a fact that the judge assigned to that case has no patience or no tolerance for that particular argument. I could be that a certain action or inaction which the party wants the attorney to pursue would so rankle the opposing counsel or the opposing party that what's to be gained from that action would only extend out the case for several more months, and there would not be a zero-sum gain from that course of action. It could be that because the course of action desired is based entirely on an allegation, which is impossible to prove for any number of reasons, all of which I'm certainly not going to go through here and bore the viewers and listeners, but it could be because the allegation comes from a child or suffers from a defect in the evidence, because it's hearsay or it can't be authenticated, or it's not the best evidence that can be produced, so on and so forth. Maybe documents have been lost or are outside subpoena power. You get the idea. I don't want to beat a dead horse. But this can be extremely frustrating for a party, a parent or a spouse in a family court matter who is already under so much stress and is failing to understand why what they consider to be important evidence either shouldn't be brought or can't be brought before the family court, because attorneys have precious little control. And what's even worse is that sometimes an attorney is asked or has to make a judgment call and can't point to a rule of procedure or can't point to a rule of evidence, can't sit down with a mother or father or a husband and wife and say, I understand what you mean and I understand what you're trying to do, but I think it would be better if you did that in this other way, because I think that's in your best interest or that's in the child's best interest, because sometimes we're just making these decisions based purely on our judgment, on our spider sense. And it can be extremely difficult to relate years of experience in the family court or with a specific judge or with a specific fact pattern and relate that to a party, a frustrated party, as to why his or her mountains of text messages between the two can't come in or shouldn't come in, as to why the judge can't or shouldn't talk to the child, as to how you in fact didn't know your spouse or the other parent was drunk in a court of law, even though, of course, in the real world, you knew. This can be incredibly frustrating, and it's one of the major tensions between an attorney and a client in the family court. The judgment call, of course, is nebulous, and it seems to me that the family court attorneys, in making this explanation, are asking an awful lot of the clients and the parties to essentially trust them, despite having perhaps only met weeks or months prior. These are very gray matters. And so there's this constant tension in the manner going forward about how a case is presented between the attorney and the client. A party may want to present to the court a detailed context and past history of how it is mom and dad or husband and wife came to be before the court, what happened in Puerto Rico 4.5 years ago, what each thinks of their mother-in-law, so on and so forth. But one thing that I hope the pro se litigants listening or watching at home will understand is you cannot discuss anything, not a single thing, that occurred prior to the last order. So what does that mean? So if you're in court in June, of 2017, and you and the father of your children went to court in January of 2017, and you guys got an order that said, whatever it says X, Y, and Z. When you go back in June, you are stopped. You cannot discuss anything that happened before January 2017. The judge will cut you off. Your lawyer may tactfully tell you to shut up, because the idea is those issues should have been brought up at the January court date. And if they were so important as to be mentioned now, they could have been mentioned then. What I see often is that parties want to enter letters. This is especially true in child custody cases in which the parents were never married. Almost every client of mine like this wants to enter a bevy of letters from neighbors and coaches and friends and family about what a great parent they are. None of those letters are admissible. Not a single one. You have to bring someone to the court to testify in a stand. They cannot write letters. One party may ask the other party to submit themselves for a drug or alcohol screen without decent reason. These are not granted, and so on and so on and so forth. I don't want to belabor the point, but you can see that there is a clear dichotomy between how a stressed parent or spouse in a family court matter wants a case tried and how it in fact can be tried. Your lawyer does not have all the control you think he or she does, nor does your spouse's lawyer or the other party's lawyer. And so you can begin to see how frustrating these attorney-client discussions can be leading up to a contested child custody appearance when a party has all of this evidence, or they certainly think they have all of this evidence with them on their court date, and in fact all of it is defective or inadmissible or nonsense due to the picayune rules of the court. You can imagine that an attorney and a party would persist in this conflict throughout, and how the party would understandably come to be exasperated by their attorney for reasons unbeknownst to them, refusing to try the case and give the proper attention that the client believes is needed to their evidence. So what's an attorney to do? When there's precious little wiggle room in these cases, when you have only a little bit of control, what I think we attorneys should do, and what I try to do in my cases, is to exercise every ounce of control that I do have. Most of my control as a family court attorney is actually outside of the court. And what do I mean by that? I can, if you have a receptive client, I can withhold and reveal information at times that's best for that client or detrimental to the other party. I can maintain a kind of dominion over the life choices or of a parent vying for custody of a child. If a client will listen to me, I can tell this party, this child custody party, who they should live with, who they should kick out of their apartment or house, whether they enter drug or alcohol rehab or not, and where and when and why, whether they attend mental health counseling and with whom, where they work, what shift they work, when to marry, and so on and so forth. And throughout these podcasts, I think we're going to be delineating how the family court is so distinct from the other genres of law, such as tax and bankruptcy and criminal, and I think that this might be one of the critical ones, that a knowledgeable family court attorney will understand and internalize his or her restrictions within the court for all the reasons I've detailed, and will exercise his or her control outside of the court to the better end for the client. And of course, with issues this critical and personal, it's not uncommon that clients revolt or don't take offered counsel, or even worse, they take a sliver of advice, such as who to live with or who not to live with, and they run with it in an entirely errant direction, which is even worse. And in these instances, an attorney who's already has limited control finds that he or she has even less. All an attorney can do is offer counsel, foresee issues before they arise, see problems before they arise, and smother those problems before they advance by insisting that their clients conduct themselves in a certain way for the life of the case, to offer the path of least resistance to the client, to show the client by example how cases such as his or hers have gone in the past with this judge, and try to lead that client to water and hope that they drink. Other than that, the attorney has to know what major and minor decisions the attorney should make, which the client should make, and which the judge should make, and why each is different. Should just make decisions about supervised visits, who should supervise, why and when, whether to involve DCYF, when to involve DCYF, what discovery to issue, in what form, what to ask and what not to ask, and so on and so forth. I'll give you an example of a client who I was lucky enough took my advice and ran with it. This was a post-final divorce matter, which just means that two people got divorced, and then they found themselves back in court, even though they were legally divorced, because they had some matters to tie up. And so this was an important matter to tie up, because I had the ex-wife, and she had lost the child, the little boy, in the divorce. And as always, these cases it was more complex than I'm describing in the abridged version here, but one conversation I had with the mother, who was a nurse, and I said she worked third shift at the time, and so sleeping and supervising the child was very difficult for her. But she took my advice and she ran with it, got a different nursing job on a different shift, and the rest of the case fell into place. Just like that, trying to exercise control and give counsel outside of court, because inside of court we are so restricted. An experienced family law attorney that speaks with you should tell you, once they know your case, what happened and what didn't happen, and who your judge is, they should tell you how your case is going to end. It shouldn't take months, and it shouldn't take years. Once you know who the judge is and what the fact pattern is, a good attorney can tell you how your case will end. I've come to litigate so many similar issues so many times with so many of the same judges that I've begun to internalize this kind of anticipation, and I've helped my clients benefit from what to do just as much as what not to do. I thank you so much, each of you, for joining us. We thank you in advance for your feedback, and especially for the constructive criticism as we try to move this forward. You can reach me at 401-595-1665. Even if you're out of state, that's perfectly, you don't have to be a Rhode Islander or New Englander. If you think that there's some help you can give us to our podcast, we're all ears. As well, you can reach me at timothymsweetlaw.com. Email timothymsweet@gmail.com. Thank you so much for joining us. We really appreciate it. And the next group of podcasts we do, we're going to try to be more positive, because we've done some heavy lifting in these past few weeks. Thank you so much.